All right, let's get right into it. Welcome to This Explainer. Today, we're talking about the Texas foreclosure process. But we aren't just looking at the dry law here. We're looking at this as a high-stakes game of legal chess. You know, if you're facing foreclosure and you file a state court pleading, say a temporary restraining order, well, that's really just your opening move. But what happens when the defense makes their countermove? How do you anticipate their strategy to keep your case exactly where it belongs? Let's dive in.
Okay, so when a homeowner files a temporary restraining order or a temporary injunction, a TI, to stop a foreclosure, they usually think they're just asking for some emergency help, right? But the defense's immediate countermove is almost always to yank that case straight out of state court and remove it to federal court. They do this by claiming what's called diversity jurisdiction. Basically, they argue that any local Texas defendants you named, like, say, a local trustee or property manager, were improperly joined. They're literally going to tell the federal judge that your local defendants are just shams, completely made up just to keep the case in state court.
Now, before we go a single step further, I absolutely have to give a huge shout out to the Georgia Eviction Coaching Network. This entire strategic framework, it's all theirs. They're a fantastic Georgia-based housing advocacy and eviction and foreclosure defense education mission group. Honestly, their incredible work in demystifying this exact legal chessboard is what makes an explainer like this even possible. They've totally broken down how federal judges actually read these state court pleadings, giving folks the tools to really understand the mechanics of removal and remand.
So here's our playbook for today. We're going to cover 1. The removal chess move. 2. The time of removal rule. 3. Pleading, right versus wrong. 4. Servicers and substitute trustees. 5. The missing document arsenal. And finally, the remand resistance scorning matrix. Let's get to it.
Part 1. The removal chess move, setting up the board.
Listen, if you file a vague pleading, saying stuff like, all defendants violated my rights, or the foreclosure was illegal, you're actually handing the defense exactly what they need to remove your case to federal court. A vague pleading is like a gift. It allows the defense to convincingly claim that those Texas defendants you named are just fake nominal parties. So the absolute crucial point here is understanding how the federal judge makes their decision. They use what's known as the time of removal rule. This means the judge evaluates your case based strictly on the face of your original state court petition, exactly as it existed the very second the notice of removal took effect, meaning you absolutely cannot use post-removal federal amendments to magically create new claims or theories just to get your case sent back down to state court. No way.
Which brings us right to Part 2, the time of removal rule. No takebacks. Because of that no takebacks rule, your very first state pleading has to be completely locked and loaded from day one. You can't just wait until you're standing in front of a federal judge to explain what you actually meant. Your initial document must already clearly identify the property, who is in possession, the exact roles of every single defendant, and the specific Texas laws or deeds involved. Look, while the removing defendant does carry a heavy burden to prove improper joinder, merely throwing out vague statements, that guarantees a loss for the homeowner. The federal judge needs to see a reasonable possibility of recovery or relief under Texas law against that specific local defendant. If you just say the trustee committed fraud without any specifics, well, you give the federal judge absolutely nothing to analyze and boom, your local defendant gets dismissed as a sham.
Section 3. Pleading, right versus wrong, the winning formula.
So how do we actually fix a vague pleading? Well, this 6-part formula acts as an absolute gauntlet. Every single defendant you name must be run through these exact 6 steps. Ready? 1. What is their role? 2. What was their specific act or omission? 3. What document connects them to the dispute? 4. What legal duty is involved? 5. What is the injury or threat? And 6. What specific relief are you requesting against them? If you hit all 6 of these points, you prove they are a real party and definitely not a sham.
Moving on to Part 4. Servicers and substitute trustees, the primary targets. Okay, we're now going to apply that exact 6-part formula to the 2 most critical and common defendants in pretty much any Texas foreclosure defense case, mortgage servicers and substitute trustees. Let's look at mortgage servicers first. On the weak side, a pleading might just say, the servicer had no authority. But look at the strong side. A strong pleading actually names the servicer, cites specific statutes like Texas Property Code Section 51.0025, and points out the exact missing documents, like the servicing agreement itself. By detailing the missing chain of authority that's required by Texas law, you lock that servicer into the case as a real indispensable party.
Next up, we have the substitute trustee. Now, there's a really critical legal precedent here called the Woods Framework, and it comes from a case called Woods versus U.S. Bank. Basically, it establishes that a substitute trustee is not automatically a nominal or fake defendant. If your pleading details their specific foreclosure conduct, like say issues with notices, the sales, or exactly how they were appointed, the federal judge actually has to consider their Texas citizenship, and that can entirely defeat federal diversity jurisdiction.
And this brilliantly illustrates that Wood's framework in action. A weak pleading just throws out a generic label. The substitute trustee committed wrongful foreclosure. Boring, right? But a strong pleading gets hyper-specific. It demands actual evidence, stating things like there was no written appointment before the sale, or the foreclosure affidavit is missing USPS tracking. When you demand this level of specific, physical evidence that's tied directly to the trustee's required duties, it becomes legally impossible for the defense to just brush them off as a sham defendant.
All right, Part 5. The missing document arsenal. Proving your case.
So we just talked about demanding specific evidence. Let's shift our focus entirely to the actual physical evidence you need to counter these removal arguments and properly execute our 6-part formula. A strong pleading identifies exactly what is missing, what's defective, or what's being disputed. You can't just say they lack authority. You have to point to the missing link. Where's the notice of default? Where's the USPS tracking? Where's the written substitute trustee appointment with its effective date? Or the auction affidavit? Every single one of these missing documents connects a specific defendant to a specific role. It transforms your vague complaints into concrete, facts-based legal disputes that federal judges absolutely have to respect.
Now, I really need to warn you about a massive trap here: the Anti-Injunction Act. In plain English, federal courts hate stopping state court proceedings. Like, they despise it. If your requested relief is aimed at the state judge, the justice of the peace court, or the constable, you are going to lose. Period. Never, ever aim your request at the judge. Instead, aim it strictly at the private parties. Ask the court to restrain the defendants from taking private acts to alter your current possession. You've got to keep it narrow and focus entirely on preserving the status quo.
Which brings us to Section 6, the remand resistance scoring matrix, grading your move.
We've reached the absolute climax of this explainer. I mean, how do you know if your opening chess move is actually any good? Well, the Georgia Eviction Coaching Network created this brilliant 100-point tool designed to let you objectively score your own pleading. Let's walk through the real heavy hitters on this matrix. Just look at those top 2 categories: 20 points for defendant-specific facts and 20 points for proving the Texas defendant is a real party in interest. That is 40 points right out of the gate just for following the specific formulas we discussed today. You also get points for sticking strictly to Texas law claims, clearly defining the status quo, and keeping your requested restraints super narrow and aimed at the parties, not the judges.
80 out of 100. That is your minimum target score. If your draft pleading scores an 80 or above, you've achieved a strong removal readiness posture. But if you're scoring under 40, your pleading is highly vulnerable. It's almost guaranteed to end in federal removal and likely dismissal simply because you haven't given the judge the specific facts they need to rule in your favor.
So, I want to leave you with this final, provocative thought. Are you truly defending your possession with the right legal chess moves, or are you aiming at the entirely wrong target? Before you make your opening move in state court, take a step back. Apply this framework, use the 6-part pleading formula, demand the specific missing documents, and score your strategy. Because in the legal chess match of foreclosure defense, a well-structured opening move isn't just about getting an emergency order. It's about controlling the board for the entire game. Keep learning, stay focused, and I'll catch you on the next explainer.